Number 8, the family's not aware of your plan and what their duties are. You think we'll have a plan and it's all taken care of. Well, it is to the extent that somebody knows what they should do. Quite often, people pass away and things get distributed out without even finding where the plan is or what it says. So it's a good idea to share the details with those who are going to be in control. You don't have to let them know everything, but let them know where they can find your documents.
You know, this issue, Tim, really hits home for me. Growing up, my mom's mother, my grandmother, lived with us until I was a freshman in high school, and we took care of her. She had dementia and just was unable to live on her own. My mom and my dad were heroes in taking care of her, and after she died, my aunts came out of the woodwork and wanted their share of my grandma's meager estate. Because there was no communication ahead of time, this caused a large rift between my mom and her sisters that never healed during their lifetimes. Our goal is to make sure that doesn't happen to you.
There has to be a better alternative to all of the problems that we've seen, and there certainly is. When people make a plan, there's typically 4 ways they do that. One is to put all the assets in joint tenancy, so it goes to survivors. You can also do that with a beneficiary designation that says, upon my passing, this is who will receive the assets. Many people use a last will and testament. The last is the trust. Very briefly, let me tell you about joint tenancy. First of all, we have community property in Arizona. The only way a surviving spouse will get a full step up in cost basis and wipe out the capital gains tax if it's held as community property. If it's held as joint tenancy, it does not get the full step up in basis. Secondly, if you become incapacitated, your joint tenancy deed does nothing for you to avoid all the problems we talked about with incapacity. Third, when you pass away with the joint tenancy deed, it'll go to the surviving joint tenant, but on the second death, it goes into probate, and when it comes down to the beneficiaries, they have no protection. Nor, for that matter, does the surviving spouse once it transfers to the surviving spouse. The same issues apply to a last will and testament. The difference with a last will and testament, if that's what you have, and you die with over $75,000 in your name, it will go to probate. Some people say, I don't have to worry about probate because I have a will. Probate is a Latin term, means to prove the will. So if you have a will, you will not pass go, you will not collect $200, probably $20,000 by now, and you will go to probate. So the will doesn't help the transition of your assets. It will say who receives your assets and who manages those. Also, if you have a will, when you pass away, it goes outright to all of your beneficiaries, and they have none of the protections that we've just been talking about. The only document that solves all of the problems is a property-created living trust. Now, there are hundreds of forms of living trust. Over the years, we've seen about everything you can imagine. There's a great difference in how trust works if it's done properly.